Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. April 9th and 10th, 2025 promises to be two very important days in the Idaho versus Kohberger case because this is pursuant to Judge Stephen J. Hippler's order of the 31st of January, which amended the pretrial and trial order that was rendered by the court back in October, on the 9th of October to be specific, regarding the briefing schedules for the motions in limine and also the hearing dates per that court order. And the court's order set aside the 9th and, if necessary, also the 10th of April 2025 for the hearings. And I am predicting fearlessly, just based on the large number of in limine motions, that will probably go 2 days. There are a couple of motions in limine that the defense filed that sort of harkens back to that old terminology of sticks and stones can break my bones, but names will never hurt me. These two in limine motions deal specifically with prohibiting the use of certain language during the case in chief. Now, you're not going to see that term case in chief in the pretrial and trial order. The way Judge Hippler frames the first part of the trial is the guilt phase. That is when the prosecution bears the burden of proving beyond a reasonable doubt of admissible evidence that Mr. Kohberger is guilty of the 5 crimes that he has been charged with. These are 5 first-degree felonies. This is a capital case. The ultimate penalty is on the table. He is, of course, considered innocent at all stages of these proceedings unless or until, number 1, he pleads guilty and enters into some sort of a deal with the prosecution that's then presented to Judge Stephen J. Hippler for approval, or is adjudicated guilty after the case in chief, after that guilt phase. So, what is the defense seeking here? There are 2 motions. They seek to have certain words prohibited from use. One of them he refers to as name calling. Use of words that are improper, name calling, epithets, if you will, directed towards someone, asserting an improper diagnosis, a medical condition. That's one. The other deals with prohibiting the use of the word. It's unaliving. It begins with the M word, whether it's describing the sheath, whether it is describing him. He wants those words not to be spoken to the jury during the case in chief. Under both theories and both of these motions in limine, he is arguing that they are unfairly prejudicial. It violates his constitutional privileges under state and federal law, and that in one case, in the M word case, the unaliving case, that motion in limine, he's saying that that's actually interfering with the purview of the jury. It is the jury's duty, Mr. Kohberger is saying in that motion in limine, to determine if he is guilty or not, if there's some other third party out there who has not been apprehended on the loose, or if it's one of the alternate suspects that he's pointing to. What do you think about all of this? Should these words be kept out of the trial? Should words be kept out of the case in chief? Or should, for example, the medical examiner, or if the prosecutor wants to use one of these words, should they be entitled to do so? Let me know your thoughts, your opinions. Until next time, this is Kathy. Thank you for joining us here at the Indie Zone.